So now that you have a flavor for the process, let's talk about some of the substantive areas in the law, okay? So let's look at property division. What I advise you to do is write down the word ICE-T, I-C-E-T. Good drink, good actor, good singer, but essential when it comes to property division in matrimonial law. The I stands for identify. The C stands for classify. The E stands for evaluate. And the T stands for taxes. So when you are determining how to divide property in a matrimonial action, you need to go through ICE-T, okay? Now, there are two types of property division. Some states have equitable distribution, which means that it's not an automatic 50-50, okay? And they look at various factors to determine the percentage that each spouse should get in a marriage. They'll look at age and health of the parties. They'll look at contributions to the marriage. They will look at length of marriage. They will look to see if either party also has premarital or inheritance funds, separate property. They will look at income. They will look sometimes to see if there was a premarital relationship, if there are special needs children or elderly parents that have to be taken care of. So there are many factors they can look at in determining what percentage. In community property states, they tend to look at the whole pot and divide it 50-50. But we have to determine what's the whole pot and what's marital and what's separate. So, going back to our ICE-T, the I identify. We need to identify all the assets and all the debts. So we discussed many of them before. Businesses, in some states, professional degrees, pensions, insurance policies that have whole cash surrender value, okay? Stocks, bonds, bank accounts, right? Real estate, cars, sometimes it's art collections. Some of them are tricky. Sometimes it's royalties. If one spouse created music or art during the marriage that's of value, there could be a value to that through royalties, okay? So that has to be looked at as well. Anything that has value could be considered an asset. And the debts we've identified before, credit card debt is huge, usually, especially after 2008. Before 2008, pensions constantly went up, but now a lot of times they've gone down. So it's important to get current values. It used to be that you had a right to your spouse's pension from date of marriage till date of summons. But sometimes the date of summons, the value is higher and you don't have it anymore. You can't give it if you don't have it. So those current values are very important to get, okay? But we'll get to that when we talk about the E, the evaluate. So you identify all the debts as well. Promissory notes. Sometimes to pay attorney fees, they've had to borrow money from family. There may be notes on that, okay? All right. So that's identify. You don't worry whose name it's in. You don't worry when it was acquired. It's like the menu, the tasting menu in a good restaurant, okay? Or the laundry list or the ingredient list on a recipe, okay? Then you get to C. You classify the items as either marital or separate property, okay? In many states, separate property is inheritance, a gift to one spouse, a gift to only one spouse. Now, gifts between spouses during the marriage is considered marital property. So is the engagement ring separate or marital? The engagement ring is separate property because it was given prior to marriage. The wedding ring, however, marital. Okay? So that's an example. I have one case that they never married, but the engagement ring was worth a pretty penny, $90,000. And because they never married and the relationship is over, the other one's asking for it back. There is some case law that if the marriage wasn't consummated, they should give the ring back. But in that case, he also bought many expensive gifts, and he never actually proposed. He was the one who didn't want the marriage. So I'm arguing that it was a pattern of expensive gifts, not particularly an engagement ring. So you see the art of family law, creativity, and you must, fact specific. You must look at it, okay? I hope you're not scared to share and to be generous with people after this. In any case, what else is considered separate property? If you had a pension before the marriage and you did nothing to make that pension go up in value, you didn't add any money, you didn't do any stock deals, it simply went up due to passive appreciation. Is that pension marital or separate? That pension is separate, okay? So inheritance, gift to just one spouse, also disability awards in many states are considered separate. Personal injury awards, except the contribution part. Sometimes there's a contribution to spouse part that could be considered belonging to the other spouse. Those are all separate. Everything else, one second, everything else acquired during the marriage is marital. And I will now give you exceptions to that. But I'll take this question.
Sorry to interrupt.
No, don't interrupt. Please interrupt.
What about real estate that you purchased before the marriage but then lived in after your
Okay.
separate?
Marital home or not marital home?
When you say marital home?
Was this where the couple lived in the marriage?
Yes.
Okay.
But purchased by one
Before the marriage. This is an excellent question. The question is basically, is a piece of real estate considered marital or separate if it was purchased before the marriage by one spouse and then lived in by both spouses during the marriage? I cannot tell you how many cases there are on this issue. So let's discuss it. Let's take it apart. It's a good example, okay? One spouse acquired it before the marriage. Thus, that would qualify as separate property in many states. However, during the marriage, let's assume that it appreciated in value. If it depreciated in value, it remains separate property, okay? Another question would be asked, was the deed ever put in joint names or just stayed in one name? Stayed in one name, okay? If it had been transmuted into joint name, then obviously there was an intention to share. That would make it marital, okay? But it stayed in one name. So now we must look at the appreciation. One way that separate property becomes marital is if there was active appreciation, okay? But let's look at it. With real estate, a lot of times it goes up in value due to the market. That's passive appreciation. That's not marital. So in many cases, if it was purchased before the marriage and solely went up in value due to the market, we would call that's passively appreciating and is not considered marital property. But let's change the example, and let's say that both parties contributed to the mortgage, made contributions, or contributed to renovations. Is any part of that appreciation now marital, okay? If the party who was the separate owner before the marriage paid all the bills and never let the other spouse contribute to the bills, then it would remain separate. That would be separate. But let's say during the marriage, Both parties helped maintain the house, paid the bills for the house, not the utilities, but the actual mortgage, and also paid for renovations. This is when you may get to the E, evaluate, and you might hire a real estate appraiser. Retain a real estate appraiser to value how much of the appreciation is due to passive market forces and how much of it is due, let's say, to the increase in renovation that improve the property, the improvements, okay? And then the court can also look at, well, should the other spouse get something because they helped maintain the house and they helped pay the bills for the house, the mortgage. Certainly, if the non-titled spouse paid the mortgage alone and they reduced the principal of the mortgage, I've seen cases just give credit for that reduction in principal, and I've seen courts transmute it into joint. So the key is, if you do have a piece of property that you acquire before the marriage, what are you going to do? You're going to make sure that the other spouse doesn't contribute to those bills and they don't pay for the improvements, which may seem unfair because if they had to rent a place, they might contribute. So then you would make the creative argument, the art of family law, again, that, well, this is the same like a rent, but it doesn't take account of the main portion that I paid most of the bills and that I put the down payment and that it was purchased before the marriage. This is an area where your advocacy skills come in handy. Yes? Quickly.
In New York, income is marital property, right?
Income is not an asset. It's
No,
not,
but
so it's not property.
So if it's income earned during the marriage and the other spouse contributes, let's say they have a joint account and both of them put their money into that account, and from that account, one or both of them writes the mortgage check. Why does that not make it a marital asset, or at least partially?
Well, that would be the argument that it's just what I was saying, is that could make an argument that part of the appreciation is marital because both contributed to the mortgage. Okay, but we're talking about a case here where the deed is only in one name and was acquired before the marriage, okay?
I mean, even
Yeah.
in that case, it seems.
Well, then you have to make the argument that it appreciated in value because these bills were paid jointly. So that gets taken into account. But I said the alter argument is, well, you would have to pay rent somewhere. So that's why the cases go both ways. It's a very good question about real estate, okay? Now, if you had investment accounts that was acquired before the marriage, and then during the marriage, one or both of the spouses helped increase the value of those investment accounts by active trading, that active trading may be considered active appreciation, okay? I'll give you two examples of real cases I had. One spouse had a hot dog vending business, although in today's world we might have vegan vending soon, vegan vending business. But in the old days, although they're still all over, we had these hot dog vendings, right? So before the marriage, one spouse had hot dog vending business, only had 2 vending machines. Vending carts, not machines. During the marriage, went up to 15. And the spouse was actively involved. Got up at 6 in the morning, put the mustard on, put the roll on, was there all day. That business went up in value. Should that spouse receive a percentage of the appreciation? Absolutely. Was actively involved in the appreciation of the business because helped the business grow and was side by side. Okay? And in that case, the court did find the appreciation was marital. Another case, inheritance is separate property. If you have an inheritance, you have to see if your clients kept that in a separate account. Because separate property can lose its separateness if it is commingled. So let me ask you this question. If one spouse had an account with the inheritance, and in the same account also put their income into that account acquired during the marriage, is that account separate or is it marital? There's a good argument to make that it was commingled because these separate funds, which is the inheritance, and the income acquired during the marriage, which is marital, were commingled, even though it's still just titled in that one spouse's name and the other spouse had nothing to do with it. Some courts are tracing the separate property out. And they can do that now with good forensic accounting and giving that to the spouse. Other courts are saying it's too enmeshed, and we're not doing that. Yes?
If you put aside the legal aspects, I see what you're saying, does that create other problems, like once you're married, the spouse gets money and puts it in a separate account, the other spouse is like, wait a minute, what are you doing?
Yeah.
I don't know.
I know, because when you marry, you're supposedly sharing everything. But in today's world, people are doing prenups. And these are some of the issues that get discussed in the prenuptial agreements. Is what funds are we going to share? What funds are we going to keep separate? If you get money from your family, if I get money from my family, these are tricky issues. These are sensitive, very sensitive issues. I mean, people are putting into prenups about who stays home and who doesn't. I don't know if that's enforceable. Will income be shared? Will future pieces of real estate be shared? Will businesses be shared? It's very detailed discussions. I mean, we grow up with the myths, right? We grow up with the myths of what marriage is, especially in America, the romantic myths, all our movies, our Hollywood movies, right? They meet, they fall in love, they get married, they live happily ever after, right? It's all these fairy tales we raise our children on. But the reality of the finances and how people want to live their lives need to be discussed. I find that those people who actually discuss prenuptials or look at these issues before they get married, the practical issues, it's not a surprise to deal with it later. We all have to get comfortable talking about money, talking about lifestyles, talking about family issues. To me, the key issue is communication. So basically, I think they should have communication courses starting in preschool for family life and for employment life. And we would avoid a lot of these issues. It's the couples that don't discuss these issues that later have problems communicating that can lead to divorce. And mediation, family mediation, is very good for a discussion of these issues during a marriage and before a marriage. So we don't have to get to that. So basically, there is the concept of commingling. And the issue is, did one or both of the spouses mix joint funds with separate funds, and can you trace it or can you not trace it out? Okay? So that is the C, classifying as marital or separate property. Okay? The E stands for evaluate. Everything gets a price tag. It's like those game shows, right? Everything has to get a price tag. So how do we evaluate what something is worth? Real estate, there's a real estate appraiser. Businesses, there's forensic accountants. Okay? In some states, really only one state now, professional degrees and licenses are considered an asset. Forensic accountants are used to value that. Retirement funds, there are special experts to value retirement funds, okay? Because you can't just say, you keep the house, I keep the pension. It's very difficult. That's how it used to be done. But the problem with that is, one, the house may be worth $200,000, the pensions may be worth $500,000. It was a long-term marriage. They both helped. Maybe one raised the kids and one worked more. Maybe they both worked. So if they decide to do that, it's okay. Anything two people decide is okay. Anything a family decides is okay, as long as they're informed and they know what these things are worth and what the values are, and they agree to waive it. And that's when you have to write very strong letters as an attorney. You've been informed that the pension is worth $500,000, the house is worth $200,000, there are no other assets. After your tax impact, it's still a disparity, and you are choosing not to be compensated for the difference, and you prefer, because you have an emotional attachment to the house, you want to keep the house. These things can be done, but you must write the letter protecting yourself as an attorney and to inform the client, okay? And you also have to be careful of psychological issues, and that's why sometimes it is important to work with a psychologist, Because many times at the time of divorce, it's overwhelming for people. They have to think about their regular job, taking care of the kids. Now they have to think of legal consequences of divorce. They have to put together financial information. They have to think about their past, their present, their future. And if there's DV, if there's domestic violence, they may have low self-esteem. They may not think they deserve anything. Or the opposite could happen, where let's say one spouse is involved with a new lover and the other one feels very hurt and angry. They may want to get every dime. So the issue is, can people make informed decisions and settle a case if there's all this emotion going on? In many of the courses on matrimonial law, they're teaching neuroscience, okay? Why are they teaching neuroscience? Because there's been discoveries about the brain that when you're using the limbic part of your brain, it paralyzes the frontal lobe. The frontal lobe is where all your reasoning is. So I can't tell you how many divorce clients I have that as soon as they see their spouse or enter into a courtroom, their frontal lobe is paralyzed. They can't make any decisions. They're angry, they're hurt. It brings back things from their childhood. So I don't know if I've scared you all out of matrimonial practice, but basically that's why the team approach works, okay? So it is important to feed the information to clients slowly, step by step. They have to make the final informed decision, but you also have to watch for those red flags like you see on your iPads. What state are they in to make? Are they in a state where they can make those decisions, okay? And do they need additional assistance, financially, psychologically, etc., okay? So you classify it as marital separate. Then you put a price tag on everything. Retirement plans can get valued by pension appraisers, okay? So once you have the business appraiser determine how much the business is worth, retirement appraisers determine how much retirement funds are worth, you see that how much everything is. Cash is cash. 401k is easy. It's right on the statement. Real estate, there may be some shorthand ways. You may say to me, Ms. Donovan, how can we afford all these different experts? You know, they're a working class family. They can't afford all these experts. Well, sometimes there are certain websites that can be used, you know, or certain programs that can be used to figure out values, you know, real estate brokers, and there's other ways to get it, or you find someone who will do it cheaper, or the key is, as a lawyer, you develop relationships with all these evaluators, and you tell them, you know, the ones that can afford it, the ones that are cheaper, you try to work it out. But it is important to know the values of the items before you start trading it. And guess what the T is? Did I tell you? What did I say? Taxes? Right. Because let me ask you a question. Is $50,000 cash in the bank the same as $50,000 in an IRA? What if I say you keep the IRA? Is that a good trade for you? No, because it has to be tax impacted. When you take the money out of the IRA, particularly if you take it out early, there's taxes to pay. A Roth IRA later, maybe not. But basically, you need to figure out the tax impact. That's when you work with an accountant, even if they go for one consult, okay? But that's the proper way to do a matrimonial. A lot of people take matrimonial cases to make extra money. It's a mistake. It's an absolute mistake until you study all these rules, okay? Or you call someone experienced, you know, as a consultant to help, okay? These people's lives, it's their family. It's the past, it's the present, and the future. I mean, you're really setting a roadmap for these families, okay? So you have to consider the tax impact. Real estate, you may have to consider capital gains, stocks, and then you have to think, now, after you've done all of that, then you can talk about, is this going to be where each of us gets 50%, or is it not 50%? It used to be that it was clearly 50%, but now the case law is making arguments, well, if someone earned all the money, maybe the other one should get less, or certainly with businesses or degrees. So that's why, remember I told you about contributions to the marriage. There are tangible contributions and there are intangible contributions people make. You know, did you help your spouse with their family? Did you help them start their business? Did you help them develop their contacts as a good corporate spouse? Who took care of the children? What did that involve, taking care of the children? Okay? I did give you in the materials, and it's on my website, for those of you who are watching it online, sherrydonovan.com. There are workshops, worksheets. There are also workshops online by video. But basically, use these worksheets. It will give you more information, okay? Now, many cases, the case I had last year where the woman had the cancer, it was only a 6-year marriage, but that lawyer didn't fight me. He said, you know what? We're going to go 50-50 on the assets. We're not going to have an issue here. We're going to stipulate to 50-50. By the way, if you only 5% or so of the cases go to full trial. Full trial is very expensive. You have to try to settle along the way. And or if certain issues can be resolved, then you resolve those issues as you go. If you can resolve the child support and the custody, particularly custody and parental access, take the children out of the process as much as possible.